All right, I'd like to welcome everyone to the September 6th meeting of the Planning and Zoning Commission. Tonight on the agenda, we have 2 public hearings, 3 letters of recommendation, 1 information report, 1 correspondence item, 1 site development plan item, and 2 other items. Can I get a roll call of commission members, please?
Commissioner Helfrey.
Here.
Commissioner Ward.
Here.
Commissioner Cohn. Commissioner Broyles.
Here.
Commissioner Clayton.
Here.
Commissioner Depler. Commissioner Jackson.
Here.
Chair Beatty.
Here.
Councilmember Brost. Mayor Bolin.
Here.
Thank you.
Let's see here. Can I get an approval of the minutes from August 1st, please?
I'll make a motion
Oh.
to approve.
All right. Motion by Commissioner Helfrey, second by Commissioner Ward. Any discussion? All those in favor say aye.
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 Any opposed? Any abstained? All right, motion carries. Thank you.
Thank you.
Does the Department of Planning have any opening remarks?
No, sir, but thank you for asking.
All right, thank you. All right, at this time, we'll go into public comment session. If you want to speak on anything other than one of the 2 planning or one of the 2 public hearings, now is the time to speak and use the raise hand feature in Zoom like Mr. Griesedek has done. And we will promote you to be a panelist and let you say your words. So with that, Mr. Griesedek.
And Mr. Chair, before the department lets in Mr. Griesdick to speak, I would just also note again that we do have some in attendance here at City Hall in the community room. And if any of those would like to speak on any item that's not a public hearing item, please let me know. Thank you for that, Mr. Chair.
Thanks.
Mr. Griesdick.
Yeah, just let me know if anyone wants to come forward.
Will do. Thank you.
Mr. Chair, Mr. Griesedek should be coming on screen shortly.
Okay, I see him here. So if you can unmute, thank you, and state your name and address and then go ahead.
For your record, my name's Ed Griesedek. I'm an attorney, have offices at 5 Indian Creek in St. Louis. For the first matter I'd like to talk about, I've actually got 2 different items on your agenda. The first is for Mr. Kurtz's project. It's PZ1-22 Kurtz Nursery. Joe and I and we've had a variety, and Travis have had a variety of conversations about things. The staff has sent you a letter. We just had 2 comments or 3 comments on the staff comments that they have. I've talked to Joe about these and just wanted to bring them to your attention. The first one was a requirement under section 4F of the recommendation. 4F as in Frank, regarding cross access. And there's a request that we provide a cross access easement to the property to our south. Ours is a large commercial industrial use where for mulch storage. We've got a lot of big heavy equipment moving around, and frankly the last thing we want is a parcel is a cross access easement onto that parcel. We just think it's frankly unsafe, and we store all our inventory there, and we don't want just another easy opportunity to be able to access the site. So we go to great lengths to try and protect the site. The access is only from the front, and we would prefer not to have an access to the south. And I talked to Joe about that. I don't know that he has a huge problem with that, but I wanted to bring that to your attention. And then the second issue was section 11 regarding public space. And there's a requirement, I think it's a standard part of your typical recommendations, that saying that we provide a public space. Again, this is an industrial use. I don't know what sort of public space, I guess we'd like a little bit more clarity on what's being asked for there, and that be fleshed out a little bit, or if there's something else we can work with the city on, we're happy to do that also. So those were the comments on Kurt's Nursery. I'm happy to respond to any questions you might have, or I do have also comments for the next item on your agenda, which is PZ 922, new community church. Would you like me to proceed with that, or?
Please do. Go ahead.
Is this a proper forum for Q&A to Mr. Greasedick? Or do I need to wait until we take the matter up?
Mr. Jackson, I would ask that you wait until we take the matter up.
You got
Okay. Anything, and then the next item was PZ 5-22. And I sent a letter to Joe, which should be a part of your file. There were essentially 4 or 5 items listed on that attachment B, minor comments, but we wanted to bring them to your attention as they were contained on the attachment B. The first one was on section 2, and it was talking about our ability to illuminate the courts. This is for the community church, and they're going to have some pickleball courts. And what we wanted to be able to do was light the courts on all 4 sides of it, as opposed to just 3 sides. But obviously make sure that there's no off fall of light. And we would do that to the city's recommendation and the city's satisfaction. But just from a playability point of view, lighting a court from only 3 sides is difficult, although we recognize that we can't have any light shining on the neighbors. So that's one of the changes that we had in section 2F3. And then in section 4, there's section 4Q. One of the requirements in the original plan is that we couldn't have lighting for those sites. The revised plan does allow the lighting, but section 4Q says you can't have lighting. So it's inconsistent with itself. I think that was just missed. So please, our comment would be, please delete the last section on 4Q regarding lighting. Next one would be on 4B as in boy 2. It's regarding setbacks for the parking lot. The parking lot setback as shown on the attachment B is 275 feet from the south, and we would ask that be 250 feet to the south. We're not able to do the parking that we're planning for the site with 250 or with 275 feet. We are able to do it with the 250 feet, which is still quite a substantial setback.
Mr.
And then
Greasedick,
finally,
you have about 30 seconds.
Okay. And then finally, on the TGA on section 5, we would ask that the last sentence on page 11 be amended to read, this contribution shall not exceed the amount established by multiplying the number of parking spaces required by the following rate. What it had said was provided, and we had asked that it be required because we're providing many more spaces than are being required. That's it.
All right. Thank you for your comments.
Thank you.
Is there anyone else from the public or online who would like to speak at this time?
Mr. Chair, there's a gentleman, well, we have a few with raised hands on Zoom. If we could go to one of them. Well, one of them is public hearing. Mr. Schaefer has his hand up. If we could do Mr. Schaefer first, with your permission, I can get the gentleman in the community room set up to speak next.
Okay. Yeah. Mr. Schaefer, we'll bring you in and then let you go ahead.
So, sir.
Hello, can you hear me?
Yes, go ahead.
I just wanted to add that we had some discussion about enlarging the potential building footprint. We had what we originally showed on the site development plan was around 5,000 square feet, and we had in footprint, and we had discussed the possibility of making it taller and enlarging just to give us a little flexibility when we go to actually build. And we had discussed the possibility of enlarging the footprint to 7,500 square feet and the overall building square footage to 15,000. I was just going to bring that up. And also, I don't know if this is the right forum for this, so just tell me if it's not. But I was going to say we had also had some discussion about bringing an update on the north property, the main church building addition. So that's all I had.
Okay, thank you for your comments.
And Mr. Chair, we have Mr. Hayes here in the community room who would like to speak. It may take me a moment to get him started up, but he'll be right with you.
My name's Gary Hayes, and I live at 18801 Melrose Road, which is about a mile north of Manchester Road. So what my concerns were, I missed the first meeting and I was coming to listen tonight, and I don't know if I'll get any more knowledge as far as what's the zoning changes are going to make, but I was concerned about the sewage motion, or what they're going to do with that. And the main thing I'm here for is the well. I feel that ought to be on county water. They need to put that water in up there. It's right close thereby. And my well's been lowered twice. I'm sitting right on the bottom. And all these homes, especially homes that are going to be built there, sounds like the amount of the size of the home, they're going to have big yards and one irrigation systems, and that's just going to be too much of a drain on the well system. Everybody else that out here on wells is going to have a problem. We're running close on water now, and we tried to address this with Wildwood back in 2000, I guess it was, because I had to replace my pump motor, and a couple other people. My uncle, he lives on the road. He had to replace his, and it's not cheap. And so I just wanted those concerns brought up about a development of this size, that there's no reason why water shouldn't be there. And even if Wildwood has, Wildwood's a community, they need to step up and take the water out there if that's a problem. But the water I know it's at the post office for sure. And I think it's farther out on the old highway, a little bit farther out. So I just was wanting to question that. And that's my main comment.
All right, thank you for your comments. Travis, did you say that Mr. Downey is here for the public hearing?
Mr. Chair, Mr. Downey is the petitioner on the first public hearing.
Okay.
And there's another gentleman in the community room who's would like to speak as well.
Okay, go
He's on
ahead
his
and
way
move
out.
them forward.
Thank you.
Commissioner Helfrey?
I know that this is a public hearing, but do I need to comment now that I will be abstaining from the Mr. Downey's item just because I live in the neighborhood?
You can wait till then, but that's fine.
Thank you.
All right.
Ms. Helfrey, is this in regards to the Weller application? You said Mr. Downey. I want to make sure I have it clear.
He's for one of the public hearings coming up, and I know that we.
Okay, it's not the Weller. Okay, because the other one was in regards to that, I believe. Okay, thank you.
Okay, well, Mr. Vunic, actually, I'm just curious. I don't know who would answer this, but since it's going to be a public hearing, do I even need to abstain tonight at all, or do I have to wait till next week?
That would be next week, right?
Well, first of all, Ms. Helfrey, John Young is in attendance, and I would defer to him to make that determination. And our next meeting isn't until October.
Oh, okay, right. Sorry.
All right. we'll go ahead with the next speaker in the community room. Looks like, okay, go ahead. State your name and address and then go ahead.
That's me. Yep. Hi, I'm David Strickland, and I live at 18448 Melrose Road, South. And I have some concerns about the subdivision that's going in right across from my house. That's a beautiful piece of property there. And I have my desk set up so that I look out over that every day and see the deer and the turkeys and that type of thing. Gary had mentioned some of the same stuff that I had, so I'll shorten it a little bit. I'm concerned about two things. One is the traffic, and especially on where you're going to build the entrances to that new subdivision. I looked at the map that you sent out and it looks like one entrance is going to be right across from my driveway. And that's a very narrow road there, when that road would have to be widened to some degree if you're going to have cars coming from both sides. And they have the same concerns about the water problem. You know, I'm certainly on a well, and I assume that most of the houses in the new subdivision would be on wells. They are deep wells out in that area. Mine runs 440 feet, you know, to get good water. If you put a lot of wells on that 66 acres, it's going to somewhat affect the water table out there. So that was my two main concerns hooked on with what Gary has to say, but that is very close proximity to me. And I'm assuming these are going to be beautiful homes. That's all I had to say about it.
Thank you for your comments. Is there anyone else in the community room?
Mr. Chair, it does not appear that there are any in the community room that wish to speak at the public comment session.
All right. And last chance for those on Zoom, use the raise, Mr. Dale Hughes. Go ahead and unmute yourself and then state your name and address and go ahead.
Can you hear me now?
Yes, I can.
Okay. Dale Hughes, 18910 Melrose Road.
All right. Go ahead with your comment.
Same as Gary and Mr. Strickland. We all live out here, and I guess my biggest concern is, and I don't really know much about it. I'm just hearing bits and pieces from neighbors and stuff. But apparently they want to put a subdivision in, and that's more than the 7 houses that are allowed to be on septic without a sewer treatment plant. Is that correct?
Correct. Yeah, this discussion is about whether or not to give them a variance on individual versus one septic system.
Well, I am against that, and I just don't think it's fair. I mean, if we're going to have, we have Wildwood for a reason to keep everything protected and everybody be out here. And if they want to do that, it needs to be inside of 109 or wherever the rules change. And I don't know why there would be a variance for him to do it when right across the street in August Tavern, they have a system, and then down there across from Hawks Rest, that newer subdivision has a system. And I don't agree whatsoever that someone should be allowed to have a variant on that. There's rules and you put them in place for a reason. And I've been subject to some of those rules in the past. And, you know, so I think that and everybody knows the water problem. So that's all I have to say.
All right. Thank you for your comments.
Thank you.
Anyone else from Zoom would like to speak tonight? All right.
I
Seeing
see Thomas Downey's hand.
he's here for the public hearing. All right. Okay, so with that, we'll close public comment and go into the public hearing. Let me pull up my script real quick. In the city of Wildwood, public hearings are truly intended to accept comments and questions concerning these items. Since these requests are being presented at a public hearing, no action is planned on these items tonight, and consideration of them is to be taken no earlier than October 3rd, 2022. This approach ensures that the members of the Planning and Zoning Commission will hear all opinions before taking any action. The city's Department of Planning will address the comments, questions, and concerns that are raised tonight and include them as part of its formal recommendation to the Planning and Zoning Commission. Anyone in attendance at City Hall tonight wanting to speak should fill out a speaker's card and leave it with Mr. Newberry. Those in attendance via the Zoom webinar platform should use the raise hand feature to indicate you wish to speak at these hearings. A team member will add you to the list of speakers, which will then be communicated to me as chair, and I will invite you to speak when it is your turn. The commission will allow all parties adequate time to present their position, but all speakers are limited to 5 minutes each. Speakers will be advised when 1 minute is left in their allotted time. In addition, information on these items can be found on the city's website at www.cityofwildwood.com. The commission would like to thank you for your cooperation and participation in tonight's hearings. All right. So we have 2 public hearings. First on the agenda is PZ 11-22.
Mr. Chair, PZ 11-22, Thomas Downey, 2638 Windcrest Falls Drive, Wildwood, Missouri, 63005, care of Straight Up Solar, 11693 Lilburn Park Road, St. Louis, Missouri, 63146. A request for a conditional use permit, CUP, in the R1A 22,000 square foot resident district with a planned residential development overlay district, PRD. Street address 2638 Windcrest Falls Drive, locator number 21U210370, for the installation of roof-mounted solar panels, which are to be so situated on the dwelling as to be visible from the adjoining roadway. The request is to be reviewed in accordance with Chapter 415.120 R1A 22,000 square foot district resident district regulations of the City of Wildwood zoning ordinance, which establish standards and requirements for the installation of solar panels. The requested permit is required due to the panel's placement on the front-facing area of the dwelling, thereby causing them to be visible from the adjoining roadway. This particular site is located in Ward 2. Mr. Chair, as with any conditional use permit request, the Department of Planning would like to introduce into the record the following items: the city's charter, the city's master plan, Chapter 415 of the City of Wildwood Municipal Code, which is its zoning ordinance, and Section 415-500, which relates to conditional use permits. The file that has been developed and maintained by the City of Wildwood regarding this request, and any and all testimony or other items offered as evidence at tonight's hearing. Thank you.
Thank you, Mr. Vunich. Mr. Newberry?
Thank you, Mr. Chair. Mr. Chair, members of the Planning and Zoning Commission, the department has a very brief slideshow presentation with some exhibits just to share and to have available as part of the discussion at tonight's public hearing. The first of which is a photo rendering of the front of the home with the panels placed onto the home. The second is a plot plan of the home and the plan or the proposed placement of the solar panels indicated by the rectangles on the roof line or the roof plan. And then the next 3 are photographs of the subject site from the adjoining street, Windcrest Falls Drive. First is on the south edge of the property looking to the north. The next is looking directly at the home from the sidewalks and street. And then the final slide is a photograph of the garage area standing at the northern section of the property looking to the south. And Mr. Chair, that concludes the department's brief presentation. Department would note that the petitioner is in attendance, Mr. Downey, as well as representatives from the solar company and others.
All right, thank you, Mr. Newberry. And I'm sorry, can you show the first slide one more time? I missed that before you clicked over. All right, thank you.
You're welcome.
All right. Let's hear. Give Mr. Downey a chance to speak on this.
Hi, thank you all for what you do for the city. And this is my first time doing any meetings like this, so I apologize. I don't really know the protocols and procedures. I thought that my project manager from Straight Up Solar was here, Valerie Corey. Is Valerie here?
She is.
I think she's going to speak about any technical details on it. I think the main thing I wanted you to see was the pictures, to see that I think solar panels have come a long way in the last 10 years even. I think they look pretty darn good. I put a brand new black roof on there so that they would blend in as good as possible. I think you can see from a couple of the angles of the roof that I placed them only on the west and the east. Ideally placed for solar panels is on the south. I avoided that because you'd see them driving up the street. I wanted it to be as inconspicuous as possible while still being able to collect solar energy from the west side, which is, you get more solar energy from the west than the east side, than the back. I think that's all I really wanted to say. I'm happy if you have any questions for me, and I think Valerie has more practice at this than me, so.
All right, thank you for your comments.
Sure.
Ms. Corey?
Yeah, hi, I'm Valerie Corey. I'm a representative of Straight Up Solar. I do have a brief presentation as well, if I could present it.
Go right ahead. We do have a 5-minute time frame, but
Not
yes.
a problem. Can you see it?
Yes.
Okay, great. So as you all know, it's at 2638 Windcrest Falls Drive, and it is a roof mount solar photovoltaic installation. So this is the specifications of the system. It's a 25.01 kW DC, that's 21.29 kW AC system. It will consist of 61 REC 410 watt solar modules. This is a black frame and black backsheet. And right here is a photo of what these panels look like. It includes 61 in-phase microinverters, which are right here in the lower left. They go on the back of the panel, so these will not be visible or anything like that. And then here is a photo of the iron ridge racking, which will also be black. And then this system will also have critter guard around the entire array, and it is estimated to produce 27,992 kilowatt hours in a year. And again, this is the rendering you've already seen, as well as the same plot diagram. I wanted to show that as well. This is another site plan that just kind of shows the placement from above with some additional equipment. The only things that'll be on the outside of the home are the panels on the roof, the utility meter, which is already there, a disconnect, that is a safety disconnect that the utilities require and jurisdictions require to turn the system off in the case of any kind of emergency, a generation meter to show production, and then the Envoy and the service panel are both inside. This is a breakout of each roof and what it looks like. And you can see here in the lower right that all the components will match the shingle color of the roof. So it's they will match the roof. And then this is the specifications of the panels if you have any questions about those. But as you can see here on the rendering, it's going to look very sleek, black on black.
Thank you.
And that's all I have.
Thank you for your comments and appreciate the digital rendering. That's very helpful.
Yes, that is all, Mr. Downey.
Are there any questions or comments from the commission? Commissioner Jackson?
So, Mr. Downing and Miss Corey, this is no reflection on your proposal or you. But as a commission member, we take these matters up, and I know there's been commentary. If no one complains, they tend to go through. I know near my house, I've got a solar panels on top of a house, and they are new and sleek and everything that Mr. Downey says. We make exceptions if no one complains. If they do complain, sometimes we may not make an exception. We've had one with some ground mounts, which are obvious, right? What I would say, two things. I think this is an issue that maybe the city needs to take up with city council to maybe change the code because they are sleeker. That's something between the city council. That's a political issue. The second is inspections, which I brought up, which is at city council right now. How do you make sure batteries are properly disposed of? How do you make sure the system is in good working order? And the only way is when a home is sold. And you may live in that forever, Mr. Downey. I don't know. So that would be the two issues, but we take these issues up. We grant exceptions to the code. We need to think about it as technology has changed. And that's just a statement. I'll just stop right there.
Can I respond? Thank you for being open-minded about it. I don't think there are any batteries. Am I missing something, Valerie?
No, you're not. There are no batteries with your system.
Yeah.
Okay, in some there are, and there are battery backup, but you don't. Okay, that's fine. But inverters go bad every 12 to 13 years and things of that nature, making sure they're in good working order safely. That's a city inspection. It has nothing to do with your proposal, Mr. Downey, whatsoever. I definitely am for greener technologies. Nothing, I just want to make a general comment. These matters come before the P&Z quite consistently. And that's why I made the comment. Nothing on you.
Okay, thank you.
Councilman Brost?
Yeah, I guess along with what Scott said is I think we just have sort of an ongoing conflict with the city's policy and on solar. Now, Mr. Downey, now I do have solar on my roof. It's not visible, even though I'm secluded on 5 acres, it's still not visible from my road. But we do have to follow, the ordinance that we have in place. And that's sort of the predicament that we're in here. Also, as a follow-up, I did have to replace some inverters. I have the same mini in-phase inverters that you're proposing. And there is a place in St. Louis where you can take them and get recycled. So I was pleased about that. But we just routinely have the same issue where there's just panels that are visible from the road. So it's, and I think, Scott, what you were saying is maybe it is something where the city just has to revisit it. Because I think this is probably one of the most common items we talk about in planning and zoning. And Mr. Vunich could correct me if I'm wrong on that. So, all right, thank you.
Any other questions or comments from the commission? Commissioner Ward.
I would just like to say from the pictures that were shown, I thought it was well done. I could barely detect them from those photos.
Thank you. Commissioner Jackson.
Yeah, going along, Mr. Bros, we set a precedent when we approve these things. So I'll just, on this one, they've done everything right. I'll make a motion to approve, but with a recommendation, city council takes this matter up to consider changing the policy
This is
Or
just
the-
a public hearing. There's no.
Oh,
motion.
okay. I'm sorry. I thought we were making an approval for it, because they've done everything right. There's no question. So anyway,
And my whole comment on the ordinance, when we last revisited it, my impression was the CUP is just so we can review the plans for street facing solar panels rather than it necessarily being a violation of the code. There are times when we've been able to get similar, when we've been able to make suggestions and get them onto the backside of the house. I'm thinking of one in Garden Valley in particular. But the CUP is just so we can review them, and there's not an outright prohibition on it, or this wouldn't be before us. Mayor Boland.
Thank you, Mr. Chairman. So there is a prohibition on front-facing solar panels that are visible from the street unless this commission grants an exception to it. So that's why this is here. So.
Commissioner Jackson, you're muted.
I'm sorry. So we make an exception for one and not someone else, and there's a fairness issue. And that's the only reason I asked that the city council take the matter up, maybe revisit it with Joe Vunich, and his team would have to do a lot of work. That's why I recommend that, because this one's a clear-cut case of doing everything right. But if we make the exception, but we don't for someone else, they say, well, you did it for Mr. Downey, but you didn't for me. There's maybe not as clear cut right now, but technology has changed. So that's my commentary. I'm done.
All right. Are there any other comments from the commission?
Mr. Chair, if I may.
Yes, sir.
Just in response to Mr. Jackson's comments, I think the intent of the conditional use permit is to allow us to look at each individual situation on its own merits and not necessarily create a pattern that we would regret. The CUP allows us to basically tailor a permit to the site characteristics and the individual area around it. So from that perspective, the CUP has that extra level of scrutiny. And certainly if in the end that level of scrutiny indicates that the installation is inappropriate, the commission has generally not authorized it. Thank you.
Mayor Boland.
Thank you. So I guess I would direct, well, is this the time, City Attorney Young, for me to direct a question to the petitioner, or should we do that later?
Mayor, this being part of the public hearing, I think it would be appropriate for you to ask a question of the petitioner. Absolutely.
At this point?
Yes, sir.
Okay. So I guess my question, and I would direct this to Ms. Corey, and correct me if I'm wrong, but I think you've been before the commission before with respect to these. Is that correct?
Yes, sir, I have. We have several project managers at the company.
Right.
I have had one other project here, and I know other project managers have as well.
Okay, thank you for confirming that. So I guess my question is a simple one. You're obviously aware that the city's rule is that the panels on the front-facing side of a home that are visible on a street are prohibited. Is that correct?
So we know that front-facing panels have a conditional use permit.
Well, it's a yes or no question. So they're, as I said earlier, they're prohibited unless a permit is issued. Correct? You're aware of that?
Yes, they're
Okay.
prohibited unless a permit is issued. Yes.
Okay. So I guess then, with that in mind, those facts in mind, my question is why we keep seeing these.
Well,
Because-
oh, go ahead.
Well, because I mean, as a practical matter, typically, I could go back and look at the votes of the commission on these, but I think far fewer rather than the many have been approved. And this one, in my opinion, and I'm going to wait until I hear all the evidence, but I mean, it's pretty visible. And I greatly respect our residents' desire to, to be energy to conserve energy and all those things. But it just seems odd to me that the tenor of the commission has been up to this point that front-facing solar panels, it applies the rules, and yet we keep seeing them. So I guess my question is, are you looking for us to change the rule, or are we going to keep seeing these every meeting until we do?
So the placement of the solar panel, so how well a system produces from solar energy is greatly dependent on the placement as far as azimuth and tilt. And so this property doesn't have a fully south-facing roof. And so the only option is to put it on the west and east roofs. And so we did want to get the customer as much production as possible, which would be using both east and west facing roofs.
And the commission considered all of that when it made the rule that is on the books now.
Mm-hmm. Yes, sir. But so the customer wanted as many solar panels as possible. So we submitted it knowing that it was a conditional use permit process. So the customer was fully aware of the hearings and everything like that. We were fully prepared to bring this to you all to make a decision. And we'd known that you had heard previous projects before and approved them in the jurisdiction as well.
Fair enough. And the only reason I mention this is because if the gist of all of these special requests coming before the commission are to try to change the rule, I learned long ago that it's very inadvisable to predict what a city council will do. And so I would just say, with all due respect, that if the intent is to have the city council look at changing the rule, I would be very careful about that, because the rule could end up being worse than what it is now.
Understood.
Thank you.
Are there any other comments? Can I get a motion to close the public hearing?
Mr. Chair, excuse me. We need to, if you don't mind, if we can offer to those attending on Zoom if they'd like to speak to the commission for the public hearing. I also have a speaker card here in the community room.
Oh, okay. I'm sorry. Go ahead and bring the person in the community room forward.
Yes, sir. Just give me a moment.
And Mr. Chair, while that gentleman approaches the screen, anyone on Zoom, if you would like to speak during the public hearing on this matter, please use the raise hand feature. Thank you.
Hello, my name is Glenn Scott. My address is 16245 Windcrest Ridge Court. I live up the street from Mr. Downey, and I'm here to speak in favor of his proposal. I waited to form an opinion until I was able to see the drawings that were published on the Planning and Zoning website Friday. And based on the drawings and the materials presented here today, it does appear to be a very sleek, modern looking installation. It does not look obtrusive to me. I do feel like in general, we should, as a city, be trying to stretch ourselves to accommodate solar to help with energy independence for our community. So I did want to come and speak in favor of this proposal. It was my understanding as a citizen, I'm not an attorney, that the point of the conditional use permit was to provide the city an opportunity to review and to verify that based on the individual merits of the installation, that there wasn't any bad, overly bad looking or problematic parts of the installation. So I do feel like the review process is working, and it is making sure that only the projects that are approved are the ones that are meet the standards and are attractive looking and for the specific installation. So that's my understanding. I could be wrong. I'm not a lawyer. So I don't mind this conditional review process. And I, as a citizen, don't feel like granting conditional use permits gives carte blanche or makes a future promise that all projects will be approved regardless of merit. So that's just my opinion. I appreciate hearing the discussion of the panel tonight. And that's all I have to say. Thank you.
Thank you for your comments. Travis, is anyone else in the community room or here? Mr. Dan Roten? Go ahead and state your name and address and then go ahead.
Dan Routen, 2128 Dartmouth Gate Court, Wildwood, Missouri. I'm sorry, 2520 Peppermill Lake Court, Wildwood, Missouri. I live in the adjoining subdivision. My only question would be to the people that specified the installation. If these panels were placed on the rear of the home versus in front of the home, what would be the reduction in production? Thank you.
If the panels were only placed on the back of the home, that would reduce the production by 47%. So almost half of the production would go away if all the panels were put on the back only.
Thank you for your answering that, Ms. Corey. Would anyone else like to speak on this?
And Mr. Chair, not to interject, but to answer your previous question, there are no other members of the public in the community room who wish to speak regarding this item. Thank you.
All right, thank you, Travis. All right, seeing no further comments, can I get a motion to close the public hearing?
I move that we close the public hearing.
All right, motion by Commissioner Ward, seconded by Councilman Brost. All those in, any discussion? All those in favor say aye.
Aye.
Any opposed? Any abstentions? All right, first public hearing is closed. Thank you. All right. Next hearing, PZ 13-22.
Thank you, Mr. Chair. PZ 13-22, City of Wildwood Planning and Zoning Commission, care of Department of Planning, City Hall 16860, Main Street, Wildwood, Missouri 63040. A request for the consideration of possible changes or amendments to various provisions of Chapter 415 of the Code of Ordinances of the City of Wildwood, including but not limited to sections 415.030, 415.090, 415.110, 415.120, 415.130, 415.140, 415.150, and 415.160 pertaining to the regulation of home occupations and home-based businesses within the various zoning districts within the city, and applicable definitions pertaining thereto in light of recently adopted state law, all wards.
Thank you, Mr. Newberry. Mr. Vunich.
Thank you, Mr. Chair. Mr. Chair and members of the Planning and Zoning Commission, as part of tonight's presentation, I will also depend on Mr. Young, our city attorney, to assist with any explanations or questions from the commission members or public. On August 28th of this year, a new law took effect that had been passed by the Missouri legislature as part of their last session relating to home-based businesses. In Wildwood, we call those home occupations. The changes to state statute broadened the allowances for home-based businesses, and several of those allowances are in conflict with the current definition of the city of Wildwood of home occupations. In the primer that has been provided, the department notes that it does now allow customers, patrons, or clients to visit the property by appointment. It restricts any hours of operation being placed upon a home-based business or home occupation. And then finally, it does restrict a prohibition on certain or particular occupations. Those are the main ones that the Department of Planning identified that if not changed in our ordinance, then therefore we would be in conflict with state statute. So tonight, the intent is to hear public comment from both the Planning and Zoning Commission, as well as anyone in attendance with an opinion on this particular matter. And then the department, along with the city attorney, will prepare an information report and recommendation for consideration by the Planning and Zoning Commission. Before the department closes, it would ask if Mr. Young has anything that he would like to add at this time. And thank you.
Thank you, Mr. Runich. Mr. Young?
I have nothing further to add, but I'm available if the commission has any questions about the effects of the bill.
All right, thank you. All right. Are there any comments from the commission on this?
I have a question.
Go ahead, Ms. Ward or Commissioner Ward.
So from what you stated or what was stated, it allows people to have clients or whatever come to their home. Is there time frames that are referenced? I mean, is it a carte blanche? Could they come at midnight or could they come? Is there any kind of time reference included? Thank you.
You're welcome, Commissioner Ward. Mr. Young?
The bill that was passed by the Missouri legislature expressly prohibits us from prohibiting clients from coming to their residence, and it also prohibits us from regulating time of the operation of their business as well.
Commissioner Jackson.
Can we not approve a business?
No.
Mr.
I'm sorry, Joe, I didn't mean to jump in and
No.
take it, but to give a brief answer, we are expressly, first of all, we can't provide any prerequisite permitting requirement. They just have to be permitted uses, and we are expressly prohibited from identifying any specific businesses that would be prohibited.
So if they brought it up individually, we can approve. So someone's a hairstylist and they people from 8 to 5. And they're, that's a very common one. We could say yes or no to that. If they wanted to get a business license, we cannot say no.
In essence, correct. We cannot identify any specific businesses, nor can we require them to even apply for a permit before operating. There's no planning and zoning process that we are any longer allowed to apply.
So anyone can start any business and there's nothing we can do about it.
Obviously, there's other laws that may be implicated depending upon the business. Obviously, you can't store hazardous waste or anything of that nature. We can still regulate what occurs outside of the home to a certain extent, but it is all after the fact regulation. We are no longer permitted to make them go through a permitting requirement before commencing their business operations.
So this is only for our information. We don't really have too much input into the outcome of this. It's just a done specific thing that we will have to deal with.
Well, what's going to happen is we are going to prepare legislation to make our ordinances now compliant with state law. And that's why this is set before you as a public hearing, because you will be seeing legislation to consider amending the city's ordinances to be compliant with the new statutes.
Thank you.
Commissioner.
So there's no zoning then. If something's zoned industrial, then we can approve an industrial business. If it's zoned rural development, like for housing, then they can just put their business anywhere. There's nothing we can do, correct?
Yeah, I wouldn't quite go that far. And the reason I say that is, again, we can still regulate things that occur outside of the home and impacts outside of the home. We can, but again, it becomes a little bit more difficult because it is going to be after the fact, after the operation. We can't say no before they start, but we can say, no, you're not allowed to do this after they start in certain circumstances.
Like, if I'm understanding this correctly, we could, like, if someone wanted to pave over their yard and put a parking lot in, we could still tell them no, correct?
Correct.
Or prohibit signage as well, I believe. Or,
correct.
Right. But yeah, if someone's going under the radar, then there's less we can do, correct?
That is correct.
All right, Commissioner Helfrey and then the mayor.
Thank you, Chair. So I'm assuming when you said, I guess I shouldn't assume, my question is when you, Mr. Young, stated that there are other ways that we can kind of regulate what goes on, would that be like parking issues? If somebody was running a business and there was a lot of parking on the street, or if they were working on doing mechanic work in the driveway, things of that nature. On the outside we can control, but things on the inside we cannot. Is that what I understand the gist of this is?
There's certain, the state laws that were passed with this bill do preserve for the city certain regulatory authority. So parking, building codes, traffic considerations, again, all after the fact, not before. But those are still preserved, and they still have to comply with state and federal laws.
Mayor Bullen? You're muted. You're muted.
Chair Beatty actually raised a great question relative to, parking lots and so forth. And I guess my question to you, John, is whether it is potentially advisable for the city to undertake a review of those other what I would call collateral rules relating to the conducting of what could potentially be some very unanticipated and undesirable home businesses at undesirable hours and so forth, to potentially therefore put before the commission a set of rules that would not only be consistent with the statutes of the state that the legislature just passed relative to the allowance of those businesses, but would also potentially further constrict certain rules relating to the conduct of the conducting of those businesses on a home-based basis. So I guess that's my question. Would it be a good idea for you or someone in your firm to look at ways in which to mitigate the effect of this on our residents through the passage of collateral legislation to do that?
Well, I'm not speaking on behalf of the department, but I believe the intent of this hearing and the intent of myself and the department is to do exactly that, Mayor, is not only make it compliant, but also change the law to maintain as much enforcement as we can under the ordinances. So there will be likely other revisions that would be considered concurrent with the limited issue of home-based business. So to answer your question in short, Mayor, yes, that's what we are looking at.
And that's why you're our city attorney. And so I would just underscore the words as much as possible. And I would also ask, when you bring that back to the commission, that you give us a brief bulleted page that demonstrates or that shows what those additional protections that you have recommended will be. Thank you so much.
Certainly.
Just going in order I see them, Councilman Brost.
Yeah, I guess if a particular subdivision in their HOA regulations, would they, I guess if something's contrary to the state law that was just passed, then that would also be void? Would that be correct?
No, it would not be correct. And that's an excellent question. The state law expressly preserves the authority of homeowners associations to enforce their regulations.
Now, is that a grandfathered, or could some of the subdivisions combat this by like actually adding to their HOA?
Correct, they could. It's not a vested right type of situation. It is, they just have the right to continue to do it as they always have.
Okay, thank you.
All right, Commissioner Helfrey.
Thank you, Chair. Mr. Young, I think that's kind of interesting that you said that about the HOA, so thank you for telling us about that. My only other question would be kind of piggybacking on what the mayor requested about when you come to us and tell us all these wonderful things that we have to deal with. One of the questions I would have would be, if there is a business ongoing inside of a home that we necessarily can't say cannot happen, is there a way to regulate that business? For example, if they were cutting hair, are they still subject to, meeting the health department requirements and having inspections? Or if they're daycare watching kids, can we require them to be subject to inspections? So I guess that would be my question. Thank you.
Yeah, and I would say that is something that we're looking at a little bit closer. The issue is that if you read the language of the bill as it's stated, it says no licensing, no permitting. You cannot require prerequisites. Now, my understanding with conversations with members of the House and Senate who supported this, they said, well, that wasn't our intent. So we'll have to see. And they still have to comply with the state law as well. And we are allowed to take such steps as are necessary to make sure they're complying with state law. So we're going to have to look at that in a holistic way, but that's what we're going to do in this process.
Now, sorry, I'll let Commissioner Clayton go next, but I want to kind of follow on with the, like on the question. There's licensing that they have to get to be a hairdresser, correct?
State licensing, correct.
Yeah. And
they'll
so
still have to comply with the state
that still applies.
Yes.
Right. Yeah.
It does.
Right, but if you, just because you have the license, if you were, for the sake of this discussion, if I was a hairstylist and I had a license to cut hair and I was at a salon to do that, I would be required to meet health department guidelines. So what would prevent me from just saying, well, I don't have to deal with all that. So I'm going to close my salon. I'm just going to do it out of my home. That's my question. There's got to be some kind of some catch-all or some fail-safe there. So I hope that we will look into that. And I thank you.
Commissioner Clayton.
Given that the Municipal League did not support this, do you anticipate that the new state legislation will be challenged in court?
I don't know if it'll be challenged in court. I have not heard of that. It's always a possibility, but I've not heard anything. I've also heard that now I'm not holding my breath, but I have been told that for the issues that have been identified, a legislative fix have been promised, but I am not holding my breath.
All right. Mayor Boland.
So Wildwood is, as all of us know, very subdivision centric. We have probably more subdivisions than any municipality in St. Louis County. All of those subdivisions have trustees, and I would make a motion that our city attorney, in conjunction with our Department of Planning, develop a letter to send to all of those subdivisions that lets them know, number one, about this development, Number two, about the need for them to have a covenant in their restrictions relative to addressing the issue. And number three, a sample covenant that they could include and pass at their next meeting. That's my motion.
I second it.
Well, this, I get what you're saying. This is a public hearing, so.
So can I make a motion at this point, City Attorney? And if not, do I need to wait until miscellaneous to do it?
A motion during the public hearing would not be the appropriate time to do it, Mayor. So I think during the miscellaneous would be the better time.
Okay, then that's when I'll do it. Thank you.
Let's hear. Commissioner Ward?
just a point of clarification. I know that we passed a no bid, what do they call them, Airbnb? Does this law nullify that?
Mr. Young, you're muted.
I don't believe it necessarily nullifies it, but we are going to have to look at what was just passed in light of this legislation. Yes.
Any other comments, concerns? Is there anyone from the public who would like to speak on this?
Mr. Chair, there are none in the community room.
Okay. If anyone on Zoom would like to speak, use the raise hand feature at this time. All right, seeing none, can I get a motion to close the public hearing? Motion by Commissioner Helfrey, seconded by Councilman Brost. All those in favor say aye.
Aye.
Any opposed? Any abstain? Motion passes. Public hearing is now closed. Thank you. All right, next on the agenda, PZ 1-22.
Thank you, Mr. Chair. PZ 1-22, Kurt's Nursery, 2312 Steamboat Hollow Lane, Wildwood, Missouri 63038, care of Edward Griesdick, EJG Legal Consulting LLC, 5 Indian Creek Lane, St. Louis, Missouri 63131. A request for a change in zoning from the M3 Planned Industrial District to the amended M3 Planned Industrial District upon a tract of land that is 15.44 acres in size, which is located on the west side of North Etherton Road, north of its intersection with Centaur Road. Street address 495 North Etherton Road, St. Louis County, locator number 18X640024. Proposed uses: a mulch storage and processing facility, composting of a range of landscape materials, agricultural and horticultural operations, landscape and maintenance operations, along with forestry and timber processing and accessory sale of products. Ward 1.
Thank you, Mr. Newberry. Mr. Vunich.
Mr. Chair, I believe Mr. Jackson has his hand raised.
Okay, so I just want to be clear because we close the public hearing, then we go right into the next topic. Outside of looking at the agenda to know what's public hearing, are we going back into a public hearing here? Or are we taking action on this one?
This one is for action.
Okay, and moving forward, can we make a motion to open public hearings, take care of all public hearing items, and then close it at the end so we can keep it straight? I can look at the agenda. I'm just wondering if we can do that because we closed one, we go into another. I just want to make sure moving forward.
Yeah, the reason that we do open and close each one is because sometimes we hold public hearings open to another meeting. And so closing that individual public hearing sends it to P&Z or the Department of Planning to do their report.
I was just trying to establish some order so I can look at the more closely to the agenda moving forward, but okay, we're taking action on this one. Fine.
All right. Go ahead, Mr. Vunich.
Thank you, Mr. Chair. Mr. Chair, members of the Planning and Zoning Commission, Tonight, the Department of Planning has prepared for your consideration the draft letter of recommendation regarding the request that has been entered into the record. The request is to amend the existing M3 planned industrial district to accommodate a mulch processing facility, a composting operation, and other uses on an industrially zoned land. At the hearing, a number of questions were raised. Those questions were addressed in the department's report. And again, the Planning and Zoning Commission endorsed such at its August meeting this year. Tonight, the petitioner's representative has identified several items for consideration. The department would note that the public space component is usually addressed by the Planning and Zoning Commission as part of the site development plan. The cross-access easement is a standard condition contained in almost all planned districts and typically as directed by the Department of Public Works and Planning. Therefore, if it is inappropriate, generally the departments will not direct such to be provided. And then finally, the standard language for the traffic generation assessment in this particular instance is consistent with past practice in that we required provided. We collect based upon provided, not required. In this instance, the department did limit the TGA fee to those parking spaces in support of the office use, and as shown on the preliminary development plan, and exempted all work equipment, vehicles, etc. from such. Tonight, the department feels the letter of recommendation in its draft form is ready for final action, and the department is available for any questions or comments. Thank you.
Thank you, Mr. Vunich. Mayor Bowen.
Move to approve the department's recommendation consistent with Mr. Benich's response to the petitioner's 3 items. Thank you.
All right. Seconded by Commissioner Helfrey. Any further discussion? All right, seeing none, roll call vote.
Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Commissioner Jackson,
Yes.
Commissioner Helfrey,
Yes.
Chair Beatty,
Yes.
Councilmember Brost,
Yes.
Mayor Boland.
Yes.
Thank you.
Passes. Thank you. All right. Next on the agenda, PZ 5-22.
Thank you, Mr. Chair. PZ 5-22, New Community Church, care of Peter Schwartz, Vessel Architecture, 600 Emerson Road, Suite 401, Creve Coeur, Missouri, 63141. A request for a change in zoning from the C8 Planned Commercial District to the amended C8 Planned Commercial District upon a tract of land that is 4.08 acres in size, which is located on the south side of Manchester Road, west of Taylor Road. Street address is 16830, 16832, 16832 Unit A, and 16840 Manchester Road. St. Louis County locator numbers 24V630352, 24V630011, 24V610068, and 24V520202. Accompanying this request is a request for a conditional use permit for the same tract of land identified herein, which would allow for the use of it for an expanded parking area for New Community Church and recreational activities associated with it as well. The subject tract of land is designated the Workplace District under the current Town Center Regulating Plan as adopted by the Planning and Zoning Commission on June 7, 2021, Ward 8.
Thank you, Mr. Newberry. Mr. Vunich.
Thank you again, Mr. Chair. Mr. Chair and members of the Planning and Zoning Commission, the department has prepared for your consideration the draft letter of recommendation regarding this particular request. As was mentioned by Mr. Newberry, it is twofold: to provide additional parking for the church membership, as well as recreational amenities for the same and potentially the general public. The department has converted the report under the authorship of the commission, reflecting its discussion and action at the August meeting on this matter. As was mentioned tonight by petitioner's representative, there are several items that they have identified for further consideration. The department would note that Mr. Newberry and I met with representatives of New Community Church. The department did its very best to adhere to what it believes best planning practices, but recognize as well unique nature of this particular request. Tonight, the petitioner is requesting an increase in the footprint of the building from 5,000 square feet to 7,500 square feet, and an overall total square footage of 15,000 square feet. The department did increase the size of the building based upon those conversations. It did not realize that the size of the building was 7,500 square feet versus 5,000 square feet. Again, the notes from the meeting did not reflect such. The field lighting was a major consideration of the department. It recognizes that in certain instances, the lighting to the pickleball courts and volleyball courts would be beneficial not only to the members of the church, but also potentially the public. However, it did make sure, in its opinion, that it would not be an imposition on the residential properties to the south, which is why it did include the restriction that no light standard can face toward the south boundary line. It is not so much an issue of trespass, but the nuisance glare from seeing the actual source of the light from those row house or attached townhomes in the villages of Cherry Hills. The department did make a couple of errors in that the setback is 250 feet, not 275 feet. I should wear my glasses more often. And then finally, the lighting requirement under 4Q, that sentence as identified needs to be struck. The department would conclude just by noting that the traffic generation assessment fee, again, is consistent with past practice and that we require it we assess it on provided parking, not required, because again, in actuality, what is provided is what is used. Oftentimes provided is much greater than required. And in the opinion of the city of Wildwood, we always want to ensure that we assess the fee based upon actual impacts. So tonight, there are a couple of changes the department has identified. And at the time of the motion, if there is an inclination to include those, the department will assist in that regard. Otherwise, the draft letter of recommendation is ready for final action. Thank you.
Thank you, Mr. Vunich. Mayor Boland.
Thank you, Mr. Chairman. And I know that the church and all of us want to get this done as soon as possible. I'm a little reticent, particularly with respect to expanding sizes to do things on the fly here. And there are apparently tentacles to this. So I'm not going to make a motion, but I would respectfully suggest to all of my colleagues, each of you here, that if the department's recommendation as it's presented is not approved, given the several tentacles, that it be postponed to the next meeting to allow the department to further assess all of those and come back to the commission with a different, if it chooses to do so, recommendation. The other thing I would say, just as a collateral item, is that with respect to Mr. Benich's comments as to lighting, I would certainly, I guess, recommend to the petitioner that my recollection from my law school days is that lighting can be a cause of action for a nuisance claim by adjoining residences. And I think the city has attempted to balance those interests, but obviously we're not representing the petitioner in that regard. But you go too far and you can end up with, I guess, what I would classify as a problem by a potential problem by adjoining landowners. So bottom line is, if there's any sentiment to expand this to any degree, I would recommend it be postponed to come back because to the commission, because there are several items. Otherwise, approve it as presented. Thanks.
Thank you. Commissioner Broyles.
I would concur with what the mayor has just said. I know approximately how big a pickleball court is, and I know the volleyball court is, but how many do they expect parking areas there, Mr. Vunich?
Well, under the proposed preliminary development plan, Commissioner Broyles, they are anticipating to build 64 parking spaces or install 64 parking spaces. They have asked for future expansion. And so the proposed letter of recommendation in draft form does accommodate that. But if there is expansion of parking, it would have to come back to the Planning and Zoning Commission.
Just for everybody's understanding, I drive this and maybe you do too, that road on Sundays. And the parking lot at the church was packed, I didn't see way in the back, but it looked like there was no space. I'm thinking that even with 60, I don't think they're going to have enough room for the 60 spots or 60 odd spots that you mentioned.
Well, Commissioner Broyles, I did not see what you saw on Sunday. I am aware that there is a parking crunch at the site. Certainly the 64 spaces will go a long way to address it. But from the city's perspective, we do want to assess appropriate traffic generation assessment fees where needed. And in this case, we want to ensure that we adhere to the regulations of the town center plan and that they are within the appropriate setbacks and screened from Manchester Road.
And for events that they have, not only just on Sunday, but the events that they have, who is going to pay for supervision from the police who are trying to direct traffic in and out of that area along Manchester Road? Not the church itself, because they have 2 entrances and exits, but this smaller land use.
Well, since the inception of this idea, Commissioner Broyles, the Department of Public Works, the Department of Planning, the city administrator have identified public safety as a key element. You know, just church members crossing Manchester Road between the 2 sites, as well as the driving public. And my recollection was that Pastor Kirkberg said that the church will provide security on the road, and it will not be at the cost of the taxpayers.
Thank you.
Any further discussion or a motion? Commissioner Helfrey?
I would make a motion to maybe postpone it just to get all the questions answered that the mayor had talked about and to get all the stuff cleaned up that Joe had talked about so that we have a much better understanding of what we're actually approving or disproving. So my motion is to postpone.
Right. Sorry, Commissioner Ward, I saw you had your hand up before I called on her. So
I was going to say the same thing, but I also wanted to clarify, is there somewhere in their plan, say they need more parking? Would that be at the expense of some of the amenities that they, suggested, like pickleball and court, volleyball courts? I mean, is there something that states that those things will happen? Or is it going to be they get it and then they see, well, we need more than 65 or whatever. Maybe we need 100, and which would cut into areas that are designated for those amenities.
Go ahead, Mr. Runich.
My apologies, Mr. Chair.
That's right.
Commissioner Ward, in the permitted uses section, it speaks to a requirement for 64 spaces. Any additional spaces would have to come back to the commission. There is no guarantee the project would move forward. However, the preliminary development plan was used to create the conditions and therefore would provide the leverage, I believe, to ensure that the amenities are provided as well as the appropriate parking.
Mayor Bullen?
Thank you, Mr. Chairman. So with the consent of the commission, well, I'm sorry, did we get a second to the motion to postpone?
No,
Well, I was giving everyone time, or I would have seconded it, just so you know.
I saw Commissioner Ward would too. All right.
So we have a motion and a second?
Now we do.
Okay.
I'll second it officially.
Okay, thank you. And then, so with permission, with the consent, and it would need to be unanimous, since a motion has been made and seconded of the commission, I would propose that if the motion to postpone is passed, that what is presented to the commission at the next meeting is a 2-page and no more than a 2-page document that shows the following things in bulleted format. Number 1, what items are we being asked to approve? And number 2, why? Number 3, what are the safety considerations for each one of them? And how are those safety considerations addressed? Number 4, what is the recommendation of the department as to each one of those and why? And number 5 and last, the additional items for square footage and more parking places or what have you, that the department may or may not want to recommend be done. Why, if you want to do it, and why not if you don't? In bulleted format, 2 pages. As long as the commission is in unanimous agreement with that.
Any opposition to that?
No, it's very clear.
Commissioner Broyles?
And I would add that it's very detailed, and I think we need those types of questions answered.
All right, so motion is to postpone till October, correct?
That's correct, sir.
All right. All those in favor say aye.
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 Any opposed? Abstain? All right, motion is postponed.
And to be clear, it's with the understanding of those provisos being part of that motion to postpone.
Mhm. All right. Next on the agenda, information report.
Actually, Mr. Chair, we have another letter of recommendation.
Oh, sorry, PZ 9-22. Sorry, I missed that one.
PZ 9-22, 2545 Etherton Road, care of Robert and Laura Busby, 8 Black Wolf Run Court, Wildwood, Missouri, 63040. A request for a change in zoning from the NU non-urban resident district and C2 shopping district to the R3 10,000 square foot resident district upon a property that is 1.05 acres in size, which is located on the west side of Etherton Road, north of its intersection with Manchester Road. Locator number 24V 530661, street address 2545 Etherton Road. The subject property is designated the Neighborhood General District under the current Town Center Regulating Plan as adopted by the Planning and Zoning Commission on June 7th, 2021. This particular property is located in Ward 8. Thank you.
Thank you, Mr. Vunich. Mr. Newberry?
Thank you, Mr. Chair. Mr. Chair, members of the Planning and Zoning Commission, the department has prepared for your consideration a draft letter of recommendation for the item that was just read into the record. The requested change in zoning would accommodate the construction of one new single-family home on the tract of land. The Planning and Zoning Commission favorably considered this request at its meeting in August of 2022, and the draft letter of recommendation reflects that action. The draft letter of recommendation is in the appropriate form to be forwarded to City Council for public hearing, consideration, and action. Thank you.
Thank you, Mr. Newberry. Mr. All right. Is there any discussion or motion? Mayor Bowen?
Well, I was waiting for someone else, but I'll make a motion to approve.
All right. Motion by Mayor Bowen. Is there a second? Seconded by Commissioner Clayton. Any further discussion? All right. Seeing none, roll call vote.
Commissioner Broyles,
Yes.
Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Commissioner Jackson,
Yes.
Commissioner Helfrey,
Yes.
Commissioner Ward,
Yes.
Chair Beatty,
Yes.
Councilmember Brost,
Yes.
Mayor Boland.
Yes.
Motion passes. Thank you. All right. All right. Mr. Newberry, the information report.
Thank you, Mr. Chair. In response to a communication dated May 12, 2022 from Mike Whalen Custom Homes regarding an application for a waiver to the city's requirements for large lot, single-family subdivisions being required to install packaged wastewater treatment plants in areas of the Wildwood community not currently serviced by public sanitary sewers, which would thereby allow for the use allow the use of individual wastewater treatment systems on each of the lots of record. This large lot subdivision is being proposed upon an approximately 66-acre tract of land located at the northeast corner of Melrose Road and State Route 100. Street address 18456 Woodlands Meadow Drive, St. Louis County, locator number 25X5200021. A total of 13 lots are being proposed as part of this residential subdivision, West Eden subdivision, Ward 1.
Thank you, Mr. Newberry. Mr. Vunich?
Mr. Chair, I believe Mr. Mayor. Mr. Mayor has his hand raised.
Mayor Boland?
Well, I just had a question, and that was relative to the wells and we've had discussion about that, and we had some people this evening from the public who spoke relative to that. Does this in any way relate to the drilling of wells and the water source for this particular project relative to that, or is this specific only to the septic system?
Mr. Mayor, it's specific to the wastewater treatment question, not related to groundwater utilization for potable water.
And then my follow-up question, thank you. With the indulgence of the chair and the commission, when will, if at all, the commission will be hearing about and deciding? And I know there's another topic on this, I think late in the agenda, but I'm not sure if it's for action. So when will the commission be looking at the issue of related topographically adjoining wells?
It's a very good question, Mr. Mayor. And as part of the subdivision process, the preliminary plat, which is likened, in my opinion, to the site development plan for planned zonings, needs to be presented to the Planning and Zoning Commission and acted upon. That is when the issue of potable water can be discussed thoroughly. And as some of the commission may know, our subdivision and development regulation speaks to the extension of public water when within 200 feet of the property or reasonably accessible. So that'll be our opportunity to address the water question.
So it's not tonight?
It will not be tonight because,
Okay.
again,
Thank
we'll
you.
have the preliminary plat.
Sounds good. Thank you so much.
You're welcome, sir.
Commissioner Helfrey?
So I'm a little confused on the order of things. So this is just for information for tonight. We're not voting on this, correct, Mr. Vunich?
Actually, the department will request a vote on this particular matter.
So you're asking us to vote on a waiver to be issued for the septic system, but we're not going to discuss anything about the wells or the potable waters tonight.
The rationale behind requesting the consideration of the waiver is that if the waiver is not granted, then an area on the site needs to be set aside for the wastewater treatment plant. The design of the lines, for the most part, needs to be thought through. So from the perspective of the department, knowing how wastewater will be treated will drive a component of the preliminary plat.
So I believe last month, if I'm not incorrect, and even earlier this evening, some people that lived in the general area and that had wells were concerned about the water and the septic systems from this new development. And so from my perspective, I don't feel like we have enough answers I personally don't feel like I have enough information to make a decision on whether granting this would be proper, because there are people that are concerned that these septic systems and the wells from this neighborhood would affect their wells and their groundwater. Am I making sense?
Well, Commissioner Helfrey, Mr. Vunich hasn't done his presentation yet either.
Okay.
So let's let him finish his presentation and then we'll continue.
My apologies. Thank you.
You're welcome.
Commissioner Helfrey, no apology necessary. Thank you. Mr. Chair and members of the Planning and Zoning Commission, tonight the department has prepared for your consideration an information report with recommendation regarding the request to waive the centralized wastewater treatment plant requirement for these proposed 13 lots. The department would note first and foremost that the site, which is 66 acres in size, could accommodate up to 22 3-acre lots under the current zoning, which is the NU non-urban resident district. That allowance of 22 lots versus the proposed 13 is a key component in the department's support for the waiver. In past instances, the Planning and Zoning Commission of the City of Wildwood has considered waivers favorably when the proposal is a significant reduction in the overall density that would be authorized by the current underlying zoning district designation. The department would note, regardless of a single treatment plant or 13 individual treatment systems on the lots themselves, all of those would be required to meet a tertiary level of treatment, meaning the highest level, so that what is discharged at the end of pipe or pipes is, for all intents and purposes, clean water that will have no impact or very, very limited impact on the quality of the aquifer and the groundwater contained therein. In the report, the department notes the unique characteristics associated with this site. It also identifies the components of the site, one of which I've mentioned is the limited density. As part of the recommendation, which is favorable, the department does note that there are a number of requirements that will be applied as well as part of the preliminary plat process, which the Planning and Zoning Commission is intimately involved in, as well as the record plat, which ultimately City Council will act upon. Those speak to the tertiary requirement for wastewater treatment from the individual systems. It requires the developer to set aside for each lot a sum of $600 so as the homeowners association will have working capital to address any problems with those individual septic systems. It also speaks to the natural resource protection standards. And again, how the trust indentures must be structured to ensure all of this is addressed. Along with that, the department is requiring that the layout of all lines be engineered, designed, so as if a plant becomes necessary, if a future subdivision of one of the existing lots is planned or the 20-acre common ground area, it is set up to accommodate such. I would note that a centralized wastewater treatment plant is, at the time when it was first discussed after the incorporation, and an idea that it is easier to police one end of pipe versus, in this case, 13. What we found in practicality is that homeowners associations are oftentimes not equipped to manage that one wastewater treatment plant. And therefore, the department's opinion has shifted over time in this particular situation. We believe that with the appropriate protections placed in the indentures and funding set aside for the future to address any problems, that the waiver would be reasonable in this particular instance. I recognize the concern regarding groundwater. In a memo that the mayor mentioned is at the end of tonight's agenda. The state of Missouri is a reasonable use water state, meaning that you can use as much water as you want, regardless of the circumstances, unless it causes a detriment, and the detriment is defined by Supreme Court case here in Missouri. However, again, we are only talking about wastewater treatment tonight. I assure you we'll have more conversations on groundwater. With that, Mr. Chair and members of the commission, the department is submitting a favorable recommendation for consideration tonight. Thank you.
Thank you, Mr. Vunich. Mayor Bowen, and then I'll come back to you myself.
Commissioner Helfrey can go first if she wants.
All right. Commissioner Helfrey.
Thank you, Mayor. Okay, I have two questions on something that you said, Mr. Vunich. One was at some point in your, when you were speaking, you said that the pipes would be laid in a way that if in the future there was a need for a centralized plant, they would be able to do so. And so my first question is, what would predicate the needing a centralized plant? And number two, one of the things that you said was that the view of the city has shifted over time to state that sometimes HOAs are not equipped to handle a wastewater treatment facility. And my question would be, what kind of oversight would there be for individual ones to give the surrounding neighbors and the city reassurances that Those are the only notes I took, so thank you.
Certainly. And as part of this particular development, there are a couple of lots, the 20-acre common ground area, as well as a 6-acre lot that could be considered for future subdivision. I know you're thinking common ground is protected, but there have been instances in the past where common ground has been converted and has been subdivided for private residences. So what the department is attempting to do is make any future subdivision so onerous with its requirements that no one would attempt it in the future. So that's why there are specific requirements in the recommendation report to ensure that that 14th lot would never happen, or at least if it were to happen, would be very, very expensive to accommodate. In terms of your second point, and could you restate that for me?
Well, one of the concerns was of the oversight of one of the things that you
Sure.
said was, I believe, and don't hold my misquote against me, was you stated that you felt that if there was one single treatment plant, that it might be onerous for our HOA to maintain it or oversee it. And so my question to you is, what kind of oversight is there if each individual homeowner has one?
Well,
That
with
makes
the,
sense.
yes, ma'am. Thank you for restating it. I do appreciate it. And when the city identified a centralized wastewater treatment plant requirement for subdivisions greater than 7 in total, or lots of subdivisions 7 or greater in total, the thought is that one end of pipe would be easy to manage. First and foremost, the state of Missouri and their permitting process and inspection requirements. What we found when we were discussing a project at the northwest corner of Pond Road and State Route 100, that process isn't as efficient as we all believed. In fact, residents opposed to that development on that northwest corner of Pond Road and State Route 100 identified a number of problem areas where a centralized wastewater treatment plant had been required. And again, we had no recognition of that from the state of Missouri at that time. So in this particular instance, what we're saying is the homeowners association with working capital is the best approach to manage those 13 end of pipes along with the individual homeowners. There will be protections in the indentures that can be enforced. And certainly there is still protections offered by the city if the septic system is foul and creating a nuisance or health hazard. So from the perspective of the department, we believe that the individual homeowner is the best police officer, so to speak, and then followed by the homeowners association itself. I wish I could say the city was also a good policeman, so to speak, or police person in this regard, but we just don't have the staffing to basically be out at the centralized wastewater treatment plants on a monthly or quarterly basis. We had depended on the state of Missouri, and I think what we found is we were disappointed by that.
All right, Mayor Boland.
Thank you, Mr. Chairman. So before I make a motion, if I do that, I just want clarification. Joe, the number of lots that could have been placed on this site, what was that number?
22.
And each of those could have had their own septic system, is that correct?
In principle, if a waiver was granted.
That's what I thought. And we have how many lots on this as being proposed? 11?
13 in
13,
total.
with one septic system. So I'm not an expert on septic systems or anything related to them, but just as a layman, that seems to be better than 22 with separate septic systems. I think with that in mind and the department's report, it seems to me that the department's report is very well reasoned. And I think Joe makes a good point, Mr. Bennett, I'm sorry, makes a good point with respect to the subdivision being responsible for what it does. And as he calls it, the working capital. And so I'm going to come back to that in a moment. But before I pull that into the motion, I just want to reiterate what Joe also mentioned relative to this coming back to the commission as the details of this are worked out. In other words, this is not the only at bat, so to speak, that the commission will get with respect to this system. So with all that in mind, my motion is that the department's recommendation be approved with one change. And that is that the working capital, as Mr. Vintage mentioned, be increased from 600 to 2,600 per lot, and that the working capital be replenished over the next 10 years for anything that the subdivision has to utilize relative to any problems that the city determines this septic system creates to any adjoining landowner. That's my motion.
All right. Commissioner Jackson, you had your hand up. I know we still need a second.
What were the results of the perk test that we were?
We actually need a second. We actually need a second, Mr. Chairman, or the motion dies. And if there is a second, then the discussion is about my motion.
Okay. All right. Commissioner Helfrey.
Okay, for clarification, in order to discuss what you just said, Mayor, we have to have a second of your motion first?
Correct.
Okay, then I'll second it. Now I have a question for you.
All right. We'll come back to you after Commissioner Jackson.
Good, thanks.
Well, as long as his comments relate to the motion.
I just want to know whether the perk test, because this new system, the septic system that's proposed has 13 lines that go into one. So essentially the field line that allows the water to dissipate is all one, becomes one. So what were the results of the perk test that we discussed during the last meeting? Did the perk test come out appropriately?
Mr. Chair, would you like me to answer that question, or do you want to proceed with a motion, a request for a second?
All right. Sorry, say that one more time.
Would you like me to answer Mr. Jackson's question, or are you seeking a second to the motion so the discussion can
No,
proceed?
Commissioner Helfrey gave her second. So
Okay.
Go ahead and answer Commissioner Jackson's question.
Commissioner Jackson, the department's recommendation is to support the waiver and forego the centralized wastewater treatment in support of 13 individual systems. The percolation tests were provided by the developer, and in all instances, the 13 lots passed the soil morphology tests that are required by the state of Missouri.
Okay, the last meeting we had, Mr. Commissioner Cone asked that question, and there wasn't one at that particular time.
There was not, yes, there was not at the meeting in August, but since that time, Show Me Soils was engaged by the petitioner and provided reports for each of the individual 13 lots.
All right. Commissioner Broyles, and I haven't forgotten you, Commissioner Helfrey.
Okay. Joe, this question's for you. With 13 lots, and you mentioned about there was enough soil or the type of soil that would dissipate that, the wastewater. How large are these 13 sites for these homes? How large are they?
Well, the lots range from 3+ acres to 6+ acres.
Okay.
The home sites, or excuse me, the homes themselves that are planned for the lots, I do not know that. We'll have more information on the home sizes as part of the preliminary plat.
So my concern was the size of the lot in acreage, and you have answered that, because you have to have in that area at least 3+ acres for individual sewers for the homes. Thank you.
And Commissioner Broyles, as a follow-up, the intent of this design is to place the home sites, the lots, on the top of the ridge. And typically in these instances, the ridge tops have the deeper soils. And in this case, based upon the soil morphology, fairly deep soils that can accommodate the effluent.
That makes sense. Thank you so much.
All right, Commissioner Helfrey.
This question is directed at the mayor. So the motion was to increase the allowance per lot to $2,600. But my question is, when you do that, and you mentioned something about the over 10 years replenishment, and you lost me there. So here's my question. From an HOA standpoint, do we require the HOA then to have a reserve at all times, or a minimum reserve, so that down the road if something should happen? I mean, how would we word that? Because I was a little fuzzy on that. Thank you.
Mayor Bullen, go ahead.
Thank you, Mr. Chairman, and thanks for the question. So the intent is that this would in fact be a reserve. The difference is the department essentially proposed the same thing, but it proposed it for $600 per lot. I would recommend it be $2,600 per lot, and that it be in place for a minimum of 10 years, so that if it is depleted to any degree over that 10-year period, then it be replenished to equal $2,600 per lot.
So, Mayor, do you feel that we need to have a minimum timeline on it? Or can we just say they have to have a reserve instead of, are you with me?
Yes, to the chair. I think we do need to have a timeline on it. Otherwise, it will be in perpetuity. I picked 10 years simply because I think that is a reasonable amount of time to hold the developer and the subdivision residents responsible for this particular system. Obviously, things deplete over time, so on and so forth, and we don't know what's going to happen, next to them with other developments and so forth. And so, I think 10 years is a reasonable amount of time. My suspicion is that the commission would have the ability, if I'm wrong on the 10 years, for that to come back to the commission at some point. And I guess I would ask that question to Mr. Vintage to change it if needed. But my gut tells me 10 years is a reasonable amount of time, that if there are no problems within 10 years, more than likely, there probably aren't going to be any. And if there are, ultimately, then I think we look at how we address those at that point. But I don't think it's fair to require, in perpetuity for, eons down the road and millions of years, the subdivision, a little far-fetched, but that the subdivision keep that kind of money in tow. I think 10 years just seems to be a reasonable number, but I guess I would ask the director of the department if he disagrees.
Mr. Mayor, I do not disagree. As with any project, although there are only 13 lots proposed, it will take a year, 2 years, or 3 years to develop those. And I think thereafter, a span of anywhere from 6 to 8 years to ensure that the installations were correctly done and that we're not having issues is appropriate.
Thank you.
Councilman Gross.
Yeah, I guess my question is, I live on a 5 acres with septic, and, there's land for sale in our subdivision. And if someone was to build, I don't know if they'd have these same requirements. And I guess my question is if there's like, if someone was to buy the 7 acres adjacent to me and build a home, would they be required to post something in the event that it would have an impact on my home? Because it seems like that's what we're doing something here that, honestly, if the perk tests are good and all that, the septic is not that complicated of a system. So I guess, it looks like we're just increasing the cost to the developer, but Mr. Vunich, can you, probably wasn't real clear, but if you could answer that.
Councilmember Broch, you were, and in your instance, that 7-acre lot would not be required to meet these same set of standards, other than the plumbing code does require a tertiary level of treatment regardless of where. And that's the highest standard of treatment of wastewater. From the department's perspective, certainly we feel that this situation justifies such because there is one lot now. It's had one house on it for many, many decades. We are adding 12 additional houses, so to speak, versus the one that was there. And as a new development, I think it's appropriate to ensure that the impacts are minimized.
Mayor Boland?
Actually, I think Commissioner Jackson was before me.
He was, but I just called on you because I thought you were responding to Councilman Brost's comment.
Okay, Mr. Chairman, if I may, and Commissioner Jackson, are you good? I was, okay. So Commissioner Brost is exactly correct. This would not, the deposit would not be a requirement that would be done relative to the lot next to him, or frankly, to the 20 plus lots that would be developed in this particular subdivision if that were the case. And I share his sentiment with respect to that. The reason I proposed the deposit is simply to strike a balance between allaying concerns of adjoining residents and those that have concerns about a larger, as Mr. Vintage pointed out, a much larger development in this particular place and only for 10 years. And I would also say, if I'm wrong on that, as we see additional information come before the commission, as we will be entitled to do relative to this particular aspect of the development, we can always up, down, or I believe reduce, get rid of it entirely. But for the sake of this evening's meeting, to move the development forward and to be fair to all parties and strike a good balance that I think is reasonable, that's why I propose that motion. But Commissioner Brost is exactly correct. It would not be required otherwise. Thank you.
Thank you. Commissioner Jackson?
So do these systems, let's just say we don't have an answer for this right now, but if they're 5,000 square foot homes, is there and there's 13 of them, is there a maximum square footage if you went by that, or however many full baths there are that these systems can accommodate that he's talking about? I mean, or can they build it and they can buy a system like this that can accommodate as big a houses as they want? That's question one. I have another one after that.
Commissioner Jackson, the sizing of an individual wastewater treatment system is premised on the number of bedrooms. And the standard is 120 gallons of capacity per bedroom. And that comes both from state statute and our local plumbing code. And so from that perspective, the size of the lots will easily accommodate even a 5, 6, or 7 bedroom house.
Okay. And so the way, if you did straight math, divide 13 by 66 acres, it's somewhere around six acres, a little less than that actually, but there's common ground. So if you're putting these houses on, one's on 2 acres and one's on 7 acres, do we know how it's going to lay out on the plat? Do we even know that?
Well, none of the lots will be less than 3 acres in size. That's the minimum required by the non-urban resident district. And yes, there is a proposed layout that's been provided as part of the department's packet of information. And it shows those 13 lots being served off a single street that's at the top of the ridge.
Yeah, because we're not taking up the well issue, and that comes into play. So,
and certainly, and the department will investigate the feasibility of extending public water, as it does with any proposal that's in the vicinity of what Missouri American Water Company can provide.
Commissioner Helfrey?
So, okay, this is my last question. So, Mr. Vunich, this reserve that the mayor has suggested, is that similar to like an escrow?
Given the 10-year time frame, I would liken it to an escrow. So eventually that money will be either depleted, or the subdivision and the developer will have an opportunity to decide how best it might be used. But the intent
Yeah, I think that's a good idea. As you know, all the nonsense we went through in our neighborhood, I think that's a great idea. So thank you. I'm not asking any more questions, I promise. Right now.
Certainly questions are encouraged, and in your particular instance, the escrow process finished the subdivision as we had all hoped.
All right. Commissioner Broyles? You're muted.
living on 3 acres, I learned a lot about septic systems and wells. And moving into an HOA 9 years ago, there was no reserve fund in this HOA that I live in. And I thought, why doesn't the state take care of that or require that? And evidently they don't, unless something has happened in the 9 years that I've lived here, because we are building up our reserve fund for lots of different maintenance items, not sewer and not water, but other things. Am I still correct that the state does not require an HOA to have reserve funds?
From the department's perspective, I know of no such statute that stipulates such. I would defer to Mr. Young again if he knows of anything in that regard.
I am not aware of any such requirement from the state.
I didn't think so.
Yeah, because just as an aside, and I'll keep this moving after this, but a coworker of mine lived in an HOA where they didn't have much in reserves, and they were constantly getting special assessments for roofs and gutters and parking lots and all of that.
Right. I just wanted to clear that up because I hadn't thought about it for a number of years now, but we pay into a fund for our HOA.
Mayor Boland?
I was going to make a motion to call a question, but if you're moving to calling the question, then I won't do that.
All right. Roll call vote.
So does everyone understand the motion?
Yes.
Okay, thank you.
Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Commissioner Jackson,
Yes.
Commissioner Helfrey,
Yes.
Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Chair Beatty,
Yes.
Councilmember Brost.
Well, I'm only going to say no because I don't like the thought of increasing the deposit, but otherwise I'm in favor. So I guess I got to say no, but I wouldn't want to stop progress. So I'll say no.
Thank you. Mayor Boland.
Yes.
All right, motion carries with one dissenting.
And for the record, Mayor Boland educated me tonight because I was dead set against this, but as we worked through this whole thing, so fair faith and credit here. I just want to say that was a great educational experience and changed my mind because I was a little concerned about this new system. Still worried about the wells. That's issue number 2.
Right.
Mayor Boland.
And my apology, commissioners, for delaying this any further, but thank you so much, Commissioner Jackson. Number one, that's what this process is all about. And number 2, you all educate me pretty much every meeting, and I appreciate that as well. So thank you.
All right, let's. All right, Mr. Newberry, new business.
Thank you, Mr. Chair. A response to a request dated August 11, 2022 from Michael Petruso, owner of CrossFit Wildwood, regarding St. Louis County PC 98-96 Manchester Woods Partnership, amended C8 Plan Commercial District, Workplace District of the Town Center Regulating Plan, south side of Manchester Road at Rockwood Point Court. Street address 16962 Manchester Road, locator number 24V510504, which seeks a modification to the site-specific governing ordinance to allow additional permitted uses to be considered in this overall development, which would include medical and dental offices and fast food restaurants without drive-through facilities. Ward 8.
Thank you, Mr. Newberry. Mr. Vunich.
Thank you again, Mr. Chair. Mr. Chair, members of the Planning and Zoning Commission, the department has provided to you a letter with recommendation regarding the request Mr. Newberry just read into the record. Mr. Pedruso is the owner of CrossFit Wildwood and is part of a 3-lot, 3-building development located in the Grover area of Wildwood. The particular building that is subject of tonight's request was the original City Hall for the City of Wildwood, and most recently, Imogene's Tea Room and Retail Store. Imogene's has been closed for several years, and there has not been a tenant located in it. Mr. Petruso has been successful in fostering SSM healthcare and a physical therapy office as part of his overall CrossFit operation. That particular use would like to expand, and Mr. Petruso would like to place it in this particular building. Along with that, Mr. Petruso would like at some point in the future to have a kind of health food operation that would offer certain drinks, foods, and other items on a walk-up window basis or as part of a sit-down situation. The department has reviewed this request and is supporting it. The department would first note that the property is located in the workplace district, and the two uses that are being requested can be considered favorably in the workplace district. The provision of tenants in this building is a positive for the historic structure itself, as well as the surrounding community. And based upon the sizes and available parking, particularly with the new streetscape, the department believes that any impacts can be mitigated by current conditions. Therefore, tonight, the department is recommending changes to the permitted uses to accommodate Mr. Petruso's request in this regard. After a motion to discuss or to proceed forward, the department will be available for any comments or questions. Thank you.
Thank you, Mr. Vernich. Any discussion or a motion? Commissioner Helfrey?
I vote to approve. Make a
I
motion to
second
approve.
it.
Seconded by Commissioner Broyles. Any further discussion? I did have one quick question. The fast food, is that just because he potentially wants to do like the health food counter or whatever?
Yes, our zoning ordinance, Mr. Chair, defines fast food restaurants as those that you can basically order at a counter, order at a window, and it's provided to you in carry-out containers. And in this instance, like I say, I think he wants to do smoothies and things like that, power drinks that, for the most part, are consistent with his theme at CrossFit Wildwood.
Thank you. I saw that and I'm like, just wondering what classifies it as fast food besides a drive-through, which we aren't allowing here, but.
Yes, let me emphasize, no drive-through facility. This would be a walk-up window or seating inside at a counter or tables and chairs.
Okay, thank you. Any further questions? Roll
I
call
may put a
vote.
drive-through at my house, baby. Now that businesses are open.
Let me
Mr. Jackson, if you wait long enough, the state of Missouri may allow that.
That's why I said it.
Roll call vote.
Commissioner Doppler,
Yes.
Commissioner Jackson,
Yes.
Commissioner Helfrey,
Yes.
Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Commissioner Clayton,
Yes.
Chair Beatty,
Yes.
Councilmember Brost,
Yes.
Mayor Boland.
Yes.
Thank you.
Motion passes. Thank you. All right. Next on the agenda, our site development plan, Mr. Vernich.
Thank you, Mr. Chair. A recommendation report from the Site Plan Subcommittee of the Planning and Zoning Commission on its review of the Site Development Plan, SDP, and related items for PZ 23 and 23A-21, Westridge Commons, McBride Barra Land Company, LLC, care of Jeannie M. Allmiller, 17415 North Outer 40 Road, Chesterfield, Missouri, 63005. R6A 4,000 square foot resident district with a planned residential development overlay district, PRD, being designated the town center workplace district. North and south sides of New College Avenue between State Route 109 and West Avenue. Street addresses 17001, 17002, 17005, 17006, and 17010 New College Avenue. St. Louis County locator numbers 24V 420362, 24V 420351, 24V 420313, 24V 420340, and 24V 420331, seeking the approval of a total of 18 attached single-family dwellings on individual lots of record with common ground and required public space areas. This site, or sites, is located in Ward 8.
Thank you, Mr. Vunich. Mr. Newberry?
Thank you, Mr. Chair. Mr. Chair and members of the Planning and Zoning Commission, the department is presenting for your consideration a recommendation report from the Site Plan Subcommittee regarding the item that was just read into the record. As it was described, the residential development in the city's town center area is the result of a change in zoning on a tract of land that was previously zoned for commercial, office, and warehouse use. This final phase of that development never came to fruition and has been vacant for many years. The current petitioner completed the change in zoning of the site to a residential use over the course of 2021 and early 2022 for 18 attached single-family units and associated improvements, including alleyways that access the rear entry garages, public space, common areas, stormwater management facilities, and visitor parking spaces. The Site Plan Subcommittee of the Planning and Zoning Commission met on August 1, 2022, and were presented a number of items to consider. The Site Plan Subcommittee reviewed these same materials, which were provided as background information for tonight's recommendation report, and provided direction to the Department of Planning to proceed forward with presentation of tonight's favorable recommendation for the approval of this site development plan package. The report from the subcommittee provides a summary of the characteristics of the development at this stage in the process, the details of which were discussed by the subcommittee at its August meeting. The department would like to note that the key to the subcommittee's discussion regarding the site development plan was the availability of parking for each of the units, and more importantly, or more notably, the number of visitor parking spaces provided in association with each of the units, particularly in proximity to the units on the north side of New College Avenue. The subcommittee was considered that there were not enough visitor parking spaces provided for those units. Over the course of the past few weeks, the department has worked with the petitioner and its engineer to address this matter as best as possible. The petitioner provided a plan sheet that now shows a reconfigured stormwater management facility at the northwest corner of the site that now accommodates 2 additional visitor parking spaces, again, to serve the 7 units on the north side of New College Avenue. With this addition of 2 spaces, there would be a total of 4 spaces at that location and a total of 16 visitor spaces for the overall site. The favorable recommendation of the Site Plan Subcommittee is premised upon its compliance with the requirements of the Town Center Development Manual, Site-Specific Governing Ordinance, the city's zoning ordinance, and subdivision and development regulations. The favorable recommendation report also notes the development of this, again, long vacant site will address current issues with property maintenance, will serve as a good transition development pattern from the commercial properties to the west and the forthcoming single-family residence plan to the east, the Ashley Grove subdivision, and it will establish a desirable walkable neighborhood with a variety and life cycle housing opportunities, amongst other positive features identified in the recommendation report. With that, the department concludes its presentation by noting that tonight, the Planning and Zoning Commission is in receipt of a recommendation from the Site Plan Subcommittee for favorable action and approval of the site development plan package for Westridge Commons. If any commission members have any questions, the department is available to address them at this time. Thank you.
Thank you, Mr. Newberry. Mayor Boland?
Thank you, Mr. Chairman, and thanks, Travis, for the report. So what I was just going to mention with this respect to this is, first of all, I think it's important that we recognize building codes are minimum standards. They're not extra, they're minimum. And secondly, what I'm going to say has nothing to do with this particular developer, because frankly, I think that this is applicable to any developer that wants to build homes in Wildwood. But I guess with that in mind, what I'm prepared to do is to make a motion to approve this proposal and the recommendation with the following proviso. And that is that I would like to ask, as part of that approval, that we grant to the department the ability to examine what I would call fundamental aspects of the structures. And there are principally three of those: foundations, walls, and roofs. And in respect to the department, if there are any additional items that it believes to be necessary within a reasonable sense to make these homes what I would call Wildwood standard homes, that it be allowed to do that. And I'm going to give you an example as to why I'm suggesting this. So a few years ago, the industry developed manufactured beams to support floors. And those manufactured beams replaced 2x10s or 2x12s. The manufactured beams had a lot of glue in them. And at the time they were approved by St. Louis County, there was no proviso that those beams be shielded from fire in a basement. But what we now know is if they're not shielded by drywall in a basement and a fire occurs, the entire house falls in. So now St. Louis County Code requires that those beams be shielded by drywall. And I think our department is best suited to look at these kinds of things and advise the commission going forward as to whether anything like that that would protect the safety of our residents is needed. So in essence, with all that in mind, my motion is that this be approved with the understanding, again, not having anything to do with this particular developer, just going forward, I'll be on this pony for anyone, that the department be given the ability to come back to the commission with any recommended improvements relative to basic code as to foundations, walls, and roofs. That's my motion.
All right, thank you. Commissioner Jackson.
I'll second it, and I have a question.
Okay, go ahead.
Are we going to have city inspectors to inspect this as it's going up? It's just a little, that just kind of adding that to it.
Commissioner or Councilman Brost.
Yeah, I guess two items, but I guess on parking, if I'm looking at these like lot layouts, you know, the one side looks like it has 8 parking spots. Does the other side have 2 or 4?
4.
4. Okay, it looks like one of the sketches may not have been updated. So that's good. It has 4. On the for Mayor Boland's glue lambs and the structural beams and that, what happened, and Mr. Vunich can expand on this. I'm retired out of the business a couple years, but the code actually changed a number of years ago, call it 3, 4, 5 years ago, where because of those types of engineered products, which are not only the structural beams, but even floor joists, the code changed to where a basement ceiling needed to be drywalled, even if the basement was not going to be finished. And what happened is that St. Louis County, they take the code as written and they may make amendments to it. So they made an amendment to it to where they did not require it. Like say on the flip side, the city of Creve Coeur, you know, they just took it, you know, based on the main residential code. So the code recognized it, but you know, the code does not necessarily mean that's what every municipality follows. And then the other thing that's always interesting is that you may have, the code comes out, it's updated every 3 years, I believe. When the 2021 code you may have a municipality that still follows a code that is 6 or 9 years old. They're not required, or well, they update, so within St. Louis and the roughly 90 municipalities, you may have municipalities following 2012 code or 2015 or 2018, 2021, but then they also can make amendments to that code. So St. Louis County, at least the last I'd heard, was not requiring a basement ceiling of unfinished basement ceiling to be drywall. So it may now, I really don't know, but the code responded to the mayor's concern, and a fireman would walk in there and with the burn time, the floors were collapsing much sooner than regular dimensional lumber. So thank you.
Commissioner Helfrey?
Thank you very much, Chair. Mr. Vunich, these questions are kind of directed at you, and they're kind of a follow-up of the site development plan. When we met with the town as a town center update committee, we talked about all of the alleys being taken over by the city. So is my assumption that the city will be responsible for these alleyways, correct?
That is the recommendation of the Planning and Zoning Commission when it adopted the town center update.
Okay, so a couple questions on this. First of all, I'll just go on the record by saying I still don't think there's enough parking, especially after the memorandum that states that the building next door doesn't want to share their parking. But I'm not gonna, it's out there. I don't necessarily think there's enough. But where is the trash can gonna go for these people, to put out their trash? Where is the mailboxes? And my last question was, when I look at the diagram, the site plan diagram that's stamped by the city of August 30th, I think it says like there's a build line of 10 foot back from the city. And I'm just curious if there's a sidewalk there, how much room will be left for the trees in light of the tree conversation we just had last week, 2 weeks ago. Okay, that's all I have. Thank you.
Each of the individual residential units will have a series of toters, one for regular trash, yard waste, well, not yard waste because there'll be common maintenance here, and then recyclables. And so they'll each have their own trash receptacles, and they'll place them in the alley where service will be provided, like in Windsor Crest, etc., which have alleys for service. In terms of the mailboxes are in clusters. That's a requirement of the Postal Service, and they are in the areas where the available visitor parking is situated. And then finally, the trees are actually part of the right-of-way. They're in grates within the sidewalk areas themselves. So that 10-foot strip, that's the build to area. There'll be additional landscaping, but that'll be at the discretion of the homeowner.
Mayor Boland? You're muted.
Thank you, Mr. Chairman. Councilmember Brost is exactly correct relative to the lay of the land, so to speak, with respect to codes and the fact that, for example, the national standards may or may not be adopted by St. Louis County, and then municipalities can do, different things. I'm definitely not a regulatory type, and I would hope that we don't have to get to the point where we supersede that. And so that's why I'm making this motion to see how it goes, which is to protect the safety of our residents, that we empower the department to use its best judgment based on what it sees in these kinds of developments relative to not aesthetics, just the fundamental parts of this development, the foundations, the walls, and the roofs. Because in the example that both Commissioner Brost and I have discussed relative to the beams and the fire and all that sort of thing, I just think we owe it to our residents to make certain that we don't allow developments to be built in the city that are compromised from at a minimum from a structural standpoint. And unfortunately, I wish I could say, as I sit here tonight, that St. Louis County's adopted the national standards, and those national standards are great and so forth. But ultimately, that's why we have the great municipality that we do. I trust the people that we retain at City Hall to make that decision, our team, for our residents. And so that's why I make that motion. Thank you.
Any further discussion? All right, so we have Commissioner Broyles.
I just have a question for Mr. Vunich. Do we have any time frame when they're going to start doing this, or do they have some more fired hoops to jump through?
Once the site development plan is approved, there is a clock ticking because the Planned Residential Development Overlay District establishes when commencement of construction must start. So
And a
they'll be
second-
moving pretty quickly.
They'll be moving quickly. The one just east of there, do we have any time frame on? I know we haven't talked about them for a while. I forgot the name of it.
Ashley Grove.
Ashley Grove. Yes, thank you. I'm just picturing this West Ridge not being completed, and they're starting the other one across to the east. And there's just not a whole lot of room on West Avenue and New College Avenue to have all that machinery and everything all happening at the same time or close to the same time.
Well, just from the standpoint of approval processes, tonight the site development plan is being presented to the Commission for action for Westridge Commons. The Architectural Review Board still has to review the units themselves. In terms of Ashley Grove, they have up to 12 months to submit their site development plan. The site development plan obviously will be reviewed by many entities, including the city, and then they also have architectural review. So I think staging wise, there'll be a bit of a gap, maybe not as much as you would like, but there'll be a bit of a gap.
Okay, thank you.
All right, any further discussion? All right, roll call vote.
Commissioner, excuse me, Commissioner Jackson,
Yes.
Commissioner Helfrey. Sorry, Ms. Helfrey, you're on mute.
Yes.
Commissioner Ward,
No.
Commissioner Broyles,
Yes.
Commissioner Clayton,
No.
Commissioner Depler,
No.
excuse me, Chair Beatty,
Yes.
Councilmember Brost,
Yes.
Mayor Boland.
Yes.
Motion passes with 3 dissenting, I believe.
Yes, sir, 6-3.
All right. Let's see. Next on the agenda, the selection of a liaison from the commission to the Historical Preservation Commission, Mr. Newberry.
Thank you, Mr. Chair. Mr. Chair, the department doesn't have much to say on this. The bylaws of the Planning and Zoning Commission say following the meeting following the appointment of the officers, a liaison to the city's Historic Preservation Commission from the commission is selected.
All right. And so Commissioner Broyles has been our liaison for the last year. And I talked to her and she would love to serve again. And so I will make my nomination that she continues as the liaison, and looking for a motion in a second. So motion by Commissioner Depler, seconded by everyone else, it looks like.
Well, we're right in the middle of Route 66. And a sundry of other things.
Voice vote, okay. All right, all those in favor say aye.
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 Any opposed? Any abstain? All right, congratulations, Commissioner Broyles.
Thank you. Thank you.
Appreciate your willingness to serve.
Thank you.
All right.
My
And
pleasure.
Mr. Vunich, water rights in Wildwood.
Thank you, Mr. Chair. Mr. Chair, members of the commission, this particular memo is not intended to provide detailed information regarding water rights and water utilization in the state of Missouri, including the city of Wildwood. It was just intended to kind of give you an idea of the reasonable use policy or requirement, and also just to talk about past actions of the city relative to water usage in the rural areas of the community. Back in 2007, the area experienced a significant drought. Potable wells on large lot areas were drying up. There were a number of items suggested. Certainly, those items were what I would consider workable. None of them were implemented other than the sustainable planning guide. So as part of our discussion of the work program in the next couple of months, maybe some of these should come back for consideration. I would note, though, that as one of the items that's still outstanding is the reoccupancy permit requirement for existing single-family residential developments. We'll be back to this commission at some point, and that's an opportune time to look at a lot of these issues as well. But this is just an item of information. If there are any questions, the department would be glad to try to answer them at this time. And certainly Mr. Young could add a great deal of information as well, given his background.
Thank you, Mr. Vunich. Are there any questions on this? All right. Seeing none, Mayor Bullen? You're muted.
We're to the end of the agenda, I believe.
Yeah. Mhm.
So I would like to make the motion that I mentioned earlier relative to home occupations, if I may.
Okay.
So as you may recall, we heard testimony earlier relative to the legislature, the Missouri legislature's actions as to the various types of home businesses that might surprise all of us. And so my motion is that we ask our city attorney, in conjunction and working with the Department of Planning, to develop a 1 to 2 page document that can be provided to all of the subdivisions that we have on record in the city of Wildwood that would contain the following items. Number one, a brief summary of that legislation and why this communication is coming to the subdivision trustees. Number two, a recommendation to those subdivision trustees as to what it may want to do relative to protecting the values and other aspects of its residents. And number three, why, and that be done all within the next 90 days. That's my motion. Thank you.
All right. Seconded by Commissioner Jackson. All those in favor say aye.
I've got a question.
Sorry. Yeah, go ahead.
So didn't you say earlier, Mayor Bolin, that you wanted the city attorney to draft some language that they could incorporate if they so choose into the HOA? I don't think that was part of your motion.
No.
Through the chair, thank you so much, Commissioner Jackson. I sort of included that within the recommendation part, but you are correct. That should be specifically stated. And so I would, without objection from anyone on the commission, since the motion's been made and seconded, agree to include that as part of that recommendation, that the city attorney includes specific language that each subdivision may want to implement.
And my part two, would it be prudent, since this is a very important issue, to send notice that send two communique? One, here's what's going on. Two, you're going to have language from us, the last part at a later date that you can incorporate into as trustees of your HOA or whatever, because then that would reinforce it. Is the only reason I recommend it. I don't care if we just do it once at one time, or if we say, here's what happened, here's what we're going to do and why. And then the second follow-up letter would be, here's the language as per our previous correspondence. And I just mentioned that just to reinforce it, that this is a very important issue.
Yeah, so I would recommend that we not do 2 communications because 1 letter can get lost and 2 letters get lost twice as bad. So I would suggest that we do it with 1 communication to the subdivision trustees of every subdivision in the city. However, relative to your comment, which is very salient, I think, Commissioner Jackson, if there's no objection, I would recommend that we publicize the fact that this letter is coming to the subdivision trustees on our Facebook page, website, and in our Wildwood newsletter and so forth.
Okay.
Any other questions or discussion on the motion? All those in favor say aye.
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 I,
Aye.
All right, any abstain? Motion passes. All right, and if no one has anything else, motion to adjourn. Motion by Commissioner Broyle, second by Councilman Gross. All those in favor say aye.
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 Opposed? All right, have a good night.
Good
So
evening.
happy we got done so soon. It's only 6:40 for me.
Nice.
You need to
Thank you
wind your
all.
watch.
I'm out in Spokane.
Oh, that's where you are. You're in a hotel. I see.
Yeah.
I was
Bye,
admiring
everyone.
your ceiling.